Hello again. The Commission for Conciliation, Mediation and Arbitration says that some employers have allegedly started firing or retrenching unvaccinated employees. Now, COVID-19 vaccination is not mandatory in South Africa. Let's get you some perspective and details from Director of the CCMA, Adv Cameron Morajane. Adv Morajane, thank you very much for your time this afternoon. Perhaps just give us an idea in terms of the cases that you are sitting with. How far and wide are they, and what are some of the merits?
Thank you very much, Dudu. Yes, indeed. As at on Friday, we had about 10 cases that we received. And fortunately, I can say that by now we've managed to resolve about 3 of the cases that we are referring to. One case which was resolved had to do with the settlement, the reinstatement. One case where parties agreed that, look, the employee must go back to work. So it was agreed, so the matter went back. And then the other 2, they've decided to settle on financial terms, which is, of course, as the CCMA, there isn't much we can do, which we encourage that parties must resolve disputes facilitated by the CCMA, especially when the matter is sitting at, at mediation or the conciliation level. We will be proceeding to about half of those matters. We are proceeding to arbitration now. This is the stage where decisions will be made, where awards will be made, either in favor of the employee or in favor of the employer. We have decided to prioritize these cases because they are of national and international importance. We are appointing senior commissioners to deal with these cases to make sure that we get the best possible outcome because of the number of factors that are affecting this type of cases. So minus those 3 that have been resolved, and we are now sitting with 7. One of the cases is a case that I personally did because of the significance that I've mentioned to. It is a case that involved a law firm where the candidate attorney or an attorney in training had a disagreement with the principal. The principal in this case, reportedly has very serious comorbidities, including pneumonia, including, being hospitalized more than once, and therefore exposure to COVID-19, according to his submission, it would have most probably, caused his death. And everyone in that firm agreed, and they went and vaccinated except one. So the candidate attorney refused to vaccinate, and then I've seen the correspondence in between the parties, and then eventually his contract was terminated, and then the case was referred to us for us to consider whether such a termination based on the refusal, whether it is in fact correct in law to do so. So that's a matter which I tried to conciliate, and unfortunately the matter was not resolved. So the matter will now proceed to arbitration. If you look at the type of cases that we're talking about, we have oral hygienists that are involved in the petrol attendant, a bookkeeper, a general worker, the candidate attorney that I spoke about, the sculpturing assistant, the storeman, and the fleet inspector and the general assistant. These are the type of persons who refer these cases that I'm referring you to. And it's between the provinces. Cape Town is about 3 of them, Gauteng, and also in KZN.
Very interesting. So we're all facing circumstances unprecedented, right? So with the case that you mentioned that has not been resolved, in my very simple thinking, please correct me if I'm wrong, this would also be unprecedented times for the CCMA. So what procedures apply?
Yes, there's 2 parts to the procedure. The first, when people challenge, this type of cases, they're using different grounds. In the main, it's unfair dismissal. But in the other ones, there's one for operational requirements. The other one has to do with unfair discrimination. Remember that these type of cases, they arise from the Equality Clause of the Constitution and also the Employment Equity as well, where you have these issues that you cannot violate my rights because I have a right to culture, I have a right to my customary practices, I have a right to religion. They raise those type of defenses. But the employer's side, what is expected at the very least, that you must conduct what we call a risk assessment of the environment on your workplace. And secondly, then develop a plan on how you're going to execute the outcomes of that risk assessment. And in the process, you engage with the employee. The employee may raise these objections based on the grounds that I'm talking about. But what seems to be one of the bigger problems is that when somebody alleges that, for example, my religion does not allow me to vaccinate, you're expected to give proof that your religion indeed does prohibit you from doing so. Failure to do so may put your case in jeopardy, that your objection may not be valid. But our approach that we're taking as a CCMA, as a mediation and a conciliating institution, is to try to mediate between the parties, because it is not in the best interest of both parties to fight about this. At the CCMA, go arbitration, lead evidence, expert witnesses, reports, medical scientist reports, and all of that. And in the end, we're going to make a decision in favor of one and against the other. And if you lose the case, you still have an option to challenge the review and go to the labor appeal court. That could take 5 to 10 years to conclude, but we're dealing with a pandemic which is currently affecting us now. That's why we prioritize mediation over the arbitration process, where one party wins. We prefer the route where both parties win. But we know that we're not going to mediate successfully all of them. In cases where we have to make a call, we will make a call, whether it is in fact procedurally correct, the manner in which it was done, and whether the decision that was taken is based on a valid reason as the law requires. Critical to this, to note, is that we all agree that decisions to dismiss an employee under any circumstances cannot be arbitrary. This one that has to do with life and death, where there's element of risk of both the employer and the employee and between the employees themselves. We encourage that the approach must be objective and acknowledging that important factor that drives that. Of course, you do what we call the balancing of interest between the employer and the employee and between the employees themselves. So that's how complex this matter is. And of course, others, like in the matter that I did, a party will say, look, the president said we can't be dismissed because of vaccinations. Why are you dismissing me? Well, post that speech, there has been regulations issued. Actually, it's not regulations, it's directions, particularly clause 3 and 4 of that talks about what needs to be done if the employer considers to have vaccination to be a mandatory one. So for it to be mandatory, it's those requirements of risk assessment, consultation, developing a plan, and making sure that the rights of the employee are not violated, especially in circumstances where they raise objections. When we make decisions, in my case, for example, because now it's our case, when I make a decision, it will be based on all those factors that needs to be considered. Witnesses will come and testify, specialists will testify, we'll make a decision in favor of one or the other. But we prefer that we find a mediated solution, because this is a matter of life and death, not about who's wrong and who's right.
It's such a fine balancing act, or a thin line, in terms of upholding constitutional rights and making sure that we've got safe working environments. I refer to the case of the law firm where they told this particular employee that, I've got comorbidities. I'm curious with the case of the petrol attendant that you mentioned, they're having brought the case to the CCMA. In terms of big businesses and small businesses, do different rules apply, or is it the same for everybody?
The rules are the same. For example, you have the same circular that applies, you've got the same directions that apply, the same Occupational Health and Safety Act that applies. What differs is the workplace and the sector of the business. For example, the circumstances of the oral hygienist and the circumstance of a petrol attendant will be different. You can imagine, how close an oral hygienist has to get to you to be able to do and execute that type of profession. The same principle cannot be exactly the same when it comes to petrol attendant. Also, in terms of creating, the zones, they're creating the social distancing and allocating rooms in the accommodation process. With the petrol attendant, in the majority of the times, they work outside, because that's where cars are, that's where you pour your petrol, but they interact with you and me when they come to us. When they come, they're wearing a mask, they sanitize the speed point, and the bank cards that we use. So there is that consideration. So the oral hygienist, it's a hygiene issue, which is about health and safety, and the whole debate is about health and safety. So the differentiation is not on the instrument that needs to be used to determine what is wrong or right, but the risk assessment that I refer to, which is also in the circular, which is also in the directions, is the one that will tell you that in this sector, in this workplace, the risk factors are the following. The best way to do this are the following. And it's a process of consensus building in the engagement to make sure that we agree, because you don't want to die, you do not want to kill somebody else. And definitely, when you're a petrol attendant or an oral hygienist, you do not want to kill the client that you're servicing or contracting from the client that you are servicing. The issue of vaccination in the mediation, what I've emphasized, that It's not so much about the issue of immunization, it's about being able to have the body ready to deal with the adverse effect in case you contract the virus. And therefore, we got to find a risk-based solution, So you cannot have the same circumstances fitting in the different circumstances, different workplaces. They all differ. But what must not happen is arbitrary decision. By arbitrary, I mean my way or the highway. You do this or else, or these are my rights, I will not vaccinate. It's a process of consensus. We engage, we agree, based on an objective risk report. We agree on how we execute the joint agreed plan for us to be able to be safe from COVID. So yes, in your answering your question, it will vary from workplace to workplace. But the law, the occupational health, the risk assessment will vary depending on the workplace because factors are different. And the plan will depend on the risk. So these are the variables. But as far as the rights are concerned, those are common amongst parties. The Constitution, the Employment Equity, LRA, including the Occupational Health and Safety, and later the Compensation Act, which is common to all parties.
COVID-19 is no respecter of titles or positions, as you have outlined. Do you anticipate, finally, that you will have more cases on your desk as time progresses?
Yes, we do, especially if you look at the timelines on how we received the 10 cases that we've received. Because some of the people that, do not know what they need to do. They do not know that you can assert those rights. They also don't know that it's not just about dismissals. You may not have been dismissed, but you could be unfairly discriminated against. That case is justiciable at the CCMA. You can refer that case. So we are now embarking on that program also to say that be aware that it's important to know that you've got rights in relation to the vaccine, but the exercise of a right will have to be objective and accommodative as well. The employer needs to do exactly the same thing. I have noted to that, Business Unity, for example, want to take this to court and ask for a declarator. That's okay, and I understand that that's what business does, and we will never question that. But for us as the CCMA, we really prefer, because of the nature of the issue that we're dealing with, that we do not adopt the contestation or the contested approach. I know that in the end we're going to end up not agreeing, but we must accept that to the extent that we can avoid going to arbitrations, avoiding going to courts, let's avoid it and do it ourselves. Don't let an arbitrator or a court decide for you, because once an order is made, you really don't have much of a choice there because an order is made. But if we agree, taking into account each other's interests and how we can accommodate, that we can do. We can spend time on that because the survival of the enterprise is important. In as much as the health and safety of an employee is also important for the survival of that enterprise. Why not share the interest, because we've got a common interest, and find a consensus-based solution and resolve it? Only in cases where all else has failed, when all else has failed, will we then end up in giving that decision to the courts and to the arbitrator. And as matters stand now, with the cases, the 7 cases I'm referring to, and like I said, I expect more, we will have to make decisions on whether the decisions procedurally that the employer followed in dismissing, whether it is procedurally correct and whether substantively taking into account the laws and the regulations, the directions that have been issued and the circulars, whether it is in fact correct that that person ought to have been dismissed. Even if in some cases where you find that the employee may have been wrong in refusing, but it does not automatically follow that dismissal is the only option that you have. Because you've got counseling, you've got corrective measures you can take, you've got education that you can take to show that before we take that. Remember that the Labor Relations Act has at its foundation security of employment. Dismissal violates that security of employment, but it does not mean that right cannot be limited, because when it comes to discipline, it is the discretion and the power that is exercised by the employer.
Adv Morajane, thank you very much. We so appreciate your time and very patiently explaining that for us. Advocate Cameron Morajane is the Director of CCMA. Thank you.